Original entry 140 in the matter of Shelley M. Joseph.
Mr. Keating, good morning.
Good morning.
We can assure you that we have carefully read your briefs as well as that of the retired justices, as well as that of the amicus, which Mr. Carey, I believe, was very much involved in
Correct, Your
drafting. So, you may proceed.
Good morning, Chief Justice Gans, members of the court. My name is Michael Keating, and together with my partner, David Cluft, we represent Judge Shelley Joseph in this matter. The matter before your honors today is a request that you reconsider your order of April 25th, 2019, suspending Judge Joseph and suspending her compensation as well. We direct our argument today specifically to the portion of your order which suspends her compensation.
Can I ask you a question about that, please? You're not contesting that we have the authority to suspend her?
I'm not.
Okay. And on what basis do you think we have the authority?
General Superintendent's power of the court, Chapter
Okay.
211, Section 3, I think, Your Honor.
And while I have you, could I ask you, do you adopt the position of the MBA on the constitutional issues in particular?
I think the MBA's position is correct. I think I have a suggestion for the court which may indicate that that's, for you, an unnecessary inquiry. Do I adopt their position? I think there's a compelling brief that the MBA and the other bar associations filed. I think there's serious constitutional issues involved when this court touches the salary of any judge. So I would say, yes, I do, although if I could, when I proceed with my argument, I think I have a suggestion which might not require the court to get deeply into that very difficult constitutional question.
Okay.
Well, then we shall not delay you.
Your Honors, we suggest that the circumstances giving rise to today's hearing present at least three matters of public importance, which we would urge the court to respect in whatever disposition the court determines. The first matter of public importance is the public's confidence in the judiciary. An indictment is a serious matter. An indictment of a sitting judge is a very serious matter. It calls into question the judge's ability to perform her core function, which is to interpret the law and thoughtfully and carefully apply the law to the parties before her. Persons in the community may perceive that a party, a judge who's under a criminal indictment does not have the capacity to do that core function as the judge is required to do. And therefore, and I think we assume that that concern for the public's confidence may have played a part in your Honor's decision to suspend Judge Joseph from judiciary duties, and we do not contest that decision here. The second matter of public importance, we believe, Your Honors, is the judge's right to compensation. We believe that right is guaranteed by the Article 29 of the Declaration of Rights of the Massachusetts Constitution, as long as it says in the Constitution, they behave well. By suspending Judge Joseph's pay, in the absence of any determination of wrongdoing, only as a result of the fact that she has been indicted, we believe violates the Constitution.
Is that where you differ with the amicus brief?
In what respect, Your Honor?
If you read the amicus brief, it says it doesn't matter. Article 29 there's a constitutional right to compensation, and whether or not someone has behaved poorly or not, or whatever the judgment is, there's a right to compensation up and until removal. Correct?
I think I would agree with that, and I think the court
That there's a right to compensation as long as they behave well. So
Well,
do you take that absolutist view or the behave well qualifier?
Your Honor, I can only look to the precedent of this court in that regard. On the occasions when you have saw fit to suspend a judge's compensation, it has always, not sometimes, always been after a determination of wrongdoing by that particular person, either a determination by a plea, a determination by a criminal proceeding, or a recommendation of the Judicial Conduct Commission on that particular case. This is the first instance, and we say this in our brief, where a judge's compensation has been suspended without any other proceeding other than the fact that the federal government has served an indictment upon her.
You know there's a personnel policy, right, for the judiciary. So anyone else in the judiciary who's indicted would be suspended without pay. If you're not a judge, so any court officer and lower level employee would be. So why would judges get a special rule?
Well, I guess one answer, Your Honor, would be that we believe that statute is not applicable to judges.
We're not talking about a statute. I think Justice Kafker is talking about a personnel trial court policy.
Yeah, we have a policy, so the court officer in this case would be suspended without pay if indicted. So we're going to treat the judges differently than all the other employees in the judicial
I think you
system.
have to. I mean, I think that's part of the constitutional argument.
Well, but but I just want to push that argument, just
Yeah.
so I understand it. So you're saying that because of the person's a judge, they have a constitutional right not to be suspended without pay in any context until conviction?
I think they have a constitutional right not to be suspended without pay without some due process.
No matter what the crime?
No matter what the crime, I think a judge has the right under the Constitution to be secure in the ascertained compensation, as the language, using the language of the Constitution.
But that only the language of the Constitution only applies to the SJC justices, right?
I'm sorry, say that again. Your Honor.
The language in the we've distinguished SJC judges from other judges in a number of our cases, right, on compensation.
My understanding would be, Your Honor, that the constitutional protections required under the Declaration of Rights apply to all judges, not just SJC
The
judges.
independence.
Pardon me?
The independence provision
Yes.
does, but the salary provision has been interpreted differently, right?
I would agree with that, Your Honor. But
But again,
I think the point here is that in this particular instance, the only fact that this court relied on, at least according to the order of April 25th, was the fact that there had been an indictment handed down. Judge Joseph has pleaded not guilty to that indictment. I know there are former prosecutors on the bench here. An indictment is a charge. It's not a conclusion. She's entitled to the presumption of innocence, and she's certainly entitled to some process, fair process.
And counsel, all that is certainly correct. But we're not dealing in a criminal context at the moment. We're concerned at the moment with the administration of justice, the superintendent's power, and so we're really in a different realm. So let's stay in that realm.
Well, we actually are in a criminal realm in this regard, Your Honor. And I hear your point. This is the only case we know of where there is the underlying offense is a criminal indictment. The other cases which we cite in our papers where there's been disciplinary action by this court, including in a couple of cases, a suspension of pay, were brought in a civil context, and normally a complaint to the Commission on Judicial Conduct. I mention this specifically for this reason. Any action by this court involving Judge Joseph, and we point this out in our papers, such as a suspension without pay after no process and after only the indictment, suggests, in my judgment, a message that perhaps in this context, the presumption of innocence and whatever is being eroded. I think that's why we have to take into account the fact that the underlying issue here is not a civil complaint, it is a criminal indictment.
Should we take into account the nature of the criminal charge, whether it's related to the function of a judge, or suppose it was under a different kind of crime?
No, because there's been no determination.
Alleged crime. But let's say, suppose it was not obstruction of justice, but it was operating under the influence or a personal domestic situation? Would there be any difference in the
Our
way you'd see
position
these?
would be, excuse me, Your Honor.
Would there be any difference in the way you would see the case?
I don't think there can be. I mean, I think the issue, when a criminal proceeding underlies this, is a difficult issue from a point of view of your determination of whether or not there's a certain factual basis to take the action you take. In the context of a criminal case, obviously, any hearing which this court might convene or might have another body convene cannot get into the underlying facts of the criminal case. I do think it could get into the remedy, though. And one of the things which I'm here to argue about today is the remedy that was promulgated by the court on April 25th. But I think it's very difficult.
Before you leave, though, I mean,
I'm sorry?
you're stressing, and everyone understands the presumption of innocence. But again, for everyone but judges, we're allowing these types of suspension without pay. So it has to be because of the function of a judge that you're creating a special rule for judges. Is that right? And the constitutional provision. But
Yes.
I'm just trying to understand how
No,
far
that's quite correct. I mean, I think we are dealing with, and this point I wanted to make, Your Honor, we're dealing with an issue here of the independence of the judiciary, which we think is a critical issue here.
Right,
We're not
but-
dealing with that issue and the issue of the court officers.
But you've already said, though, that you say we can suspend the person. So you're saying we can suspend them, we just can't suspend them without pay.
Correct. And you can suspend them, in our judgment, under your general superintendent's power. It seems to us, and I said this as my first point, that the public confidence in the judiciary is one of the three critical issues, I think, that is involved in this particular case. And I think that in that regard, we don't contest the fact that the court has the power to suspend her from her judicial duties. We think that's consistent with that.
But on the public confidence of the judiciary, how is the public going to, again, say a different crime, a judge taking bribes.
Right.
Judges taking bribes, we have pictures of, it's tape recorded, the public is all aware of it, and we're still going to keep that person getting paid, and how does that affect the confidence in the judiciary?
Well, I think it has to affect the confidence in the judiciary because the judiciary is taking the position that in the absence of some form of due process, in the absence of something other than a complaint or an indictment issued by the federal court, the court stands behind the notion of presumption of innocence and stands behind the necessity for due process. So I think it actually does enhance the public's confidence.
Do we draw that line, Mr. Keating? So if, in Justice Kafka's hypothetical, certainly not this case, but were there an allegation of bribery, probably the worst thing a judge could do for public confidence. You would say that unless and until there's a conviction of that crime, the judge can be suspended, but the judge cannot be suspended without pay.
I agree that I think that's the case, Judge.
And I think what we're trying to figure out is why is that so? Why is it so that the judge can't be suspended without pay? I'm still not
Well, because
understanding.
the judge's right to compensation is guaranteed
Absolutely.
by the Constitution.
I look at this and I see
During good
it says-
behavior, there's been no determination by this body or any other body that any of the matters set forth in the indictment actually occurred. So I think she or any other person who's indicted is entitled to all the presumptions. She's pled not guilty. She hasn't had any proceeding that would indicate anything other than the fact that she contends she's not guilty. And I think as a judge, she's charged with giving everybody who appears before her due process of law. I think she is entitled to due process of law before this panel.
What do you mean by due process?
The opportunity to be heard, the opportunity to get a determination by an impartial tribunal, whether or not an incident that's been alleged in an indictment actually occurred, the opportunity to have all the other protections that you have in a criminal case.
I've got some questions for you, but I know that you said you had 3 matters.
Right.
And we've heard only 2.
All right.
And you also said that we need not reach the constitutional
Correct.
argument, and haven't heard that yet, so.
All right.
I don't want.
Before I jump to that, Your Honor, may I make one further point on the compensation point? This issue is not a theoretical issue, of course, for Judge Joseph. This has real-life consequences for this particular judge. She's filed an affidavit in this particular case that lists some of the financial responsibilities that she is trying to fulfill. They include a mortgage, they include college tuition for 2 children, they include support for an elderly and widowed mother. These are all real-life things that everybody.
Can I push you on that just for a second?
Sure.
And I totally understand that, and I understand how grave a burden that is. But you don't want us to have a different rule for a judge who doesn't have children versus a judge who does, right? Or a judge who doesn't have a mother to take care of, and a judge who, I mean, we can't have a different rule, can we?
No, I don't contest that, Your Honor. I mean, I think the importance of the affidavit is that there are real-life consequences to this particular judge. And that situation is acerbated by 2 other facts. Number one, it's a federal criminal prosecution. We have no idea how long it will last, whether it might last years, actually, before it's finally resolved. So she lives under this non-compensation situation for that period of time. That's because, as a judge, she is severely restricted in the kinds of income she can earn if she's not earning income as a judge. So I think for both those reasons, the financial exigencies that Judge Shelley faces is more severe, frankly, than a court officer, is more severe than any other person who might actually be suspended. But I think the answer to Judge Kafka's question may actually be part of the third important public interest, and that's the independence of the judiciary. It's critical in our community, and I don't obviously have to suggest this to people on the court, that the independence of the judiciary in Massachusetts is one of the really crown jewels of our democratic system. When the judge loses her compensation on the basis of an indictment and nothing more, not any other determination, it threatens the independence of the judiciary. The MBA and the Women's Bar Association, the Mass Academy of Trial Lawyers have argued this very compellingly, I believe, in their brief, and it's not my intention to re-argue it before you today because it's set forth there and in the questions that your honors have raised with me. But let me make one observation. If the Declaration of Independence lists as a grievance compelling the colonies to separate themselves from Great Britain the fact that the king set the salaries of the judges, if that concept is carried forward in the Declaration of Rights of the Massachusetts Constitution, which it is, it's if it further carried forward in the United States Constitution in Article 3, to remove a judge's salary under any circumstances, but certainly under the circumstances where there has been no determination of wrongdoing on that judge's part, raises, I would suggest, a very serious constitutional question. I think that situation is even made more troublesome by the fact that there is a view, and it's expressed in the MBA brief, that a removal of a suspension of a judge and suspension of a judge without pay is the equivalent of a removal.
Is it?
Well, this court said it was, I think, in the Bonin case.
Governor can, does that mean that the governor can appoint a new judge?
No, I think what it means is that that the only person who
If it's
can.
the equivalent of a removal, then there's no one in the position, right? If it's equivalent to a removal, then there's no one occupying the position. Why can't the judge, why can't the
Well,
governor?
I think I said it was an equivalent of a removal.
So it's the functional equivalent, it's not the,
Yeah.
it's not really a removal at all.
Well, let me, if I might, Your Honor, respond by quoting this court's language in the Bonin decision, which I think underscores the point I'm making. We recognize that the question whether the Chief Justice should continue to serve and to receive compensation as such is one which is not assigned to the Judicial Department under the Constitution of the Commonwealth. And I think I'm only adding that factor because I think that, together with many of the other points that are raised in the MBA and the other amici briefs, underscores the difficulty of this particular issue from a constitutional.
Mr. Keating, when you look at your 3 pillars, your 3 areas of public concern or public importance, would you say that number 1 and number 3 are actually related in that the social compact or the expectation of the public is that there's faith in the judiciary, and by bestowing that faith in the judiciary, we get to act independently and make good faith
I would agree with that.
decisions. Would you agree with that?
Yes, I would. I think they're all related, to be perfectly honest with you, Judge. I mean, I've divided them into three separate
I think I agree with you on that.
boxes, but I think they're actually all part of the same issue. Let me move,
If I can, well, why don't you tell me where you're going to move, and then
okay.
I'll hold off my question until I see where you're going.
Your Honor, we suggest that there is an approach to the resolution of this matter which is attentive to all three of those important public interest matters that I've raised. And we think this approach is a path which would resolve this matter in a way which would be fair to all parties. Not only the public confidence in the judiciary, the judge's right and dependence upon her compensation, and the independence of the judiciary, those three factors. The approach that we would urge this court to consider is the following. Maintain, in effect, the order that you have entered, which suspends Judge Joseph's ability to perform judicial functions until the determination and resolution of the underlying criminal case. However, restore to her compensation, and what I would also suggest, and this may be a modification of your suspension order, that she be freed to perform administrative tasks within the court system. Judge Joseph said in her affidavit that she was not only willing, but she was eager to do that. There's no reason why she or anyone else should be compensated for not doing anything. So I would suggest that the approach that we are suggesting would be to permit the Chief Justice for Administration and Management, or the Chief Justice of the District Court, or anyone else, or this court, under your super general powers, to have Judge Joseph assigned to administrative and non-judicial tasks during the pendency of the criminal proceeding. It's beyond my knowledge, except by hearsay, to know the kinds of tasks that I think she could be productively assigned to. My understanding is that there's considerable committee work done at both the district court level and other levels of the court system. There's studies done about how do you speed up processes in the district court. There's studies about whether you should raise the age of certain of people as criminal defendants. There's issues about how do you most effectively work with the probation department. And there are many other issues that are under consideration by the justices of the trial courts. A person with Judge Joseph's background, before Governor Baker appointed her as a judge, and I'd like to state, because I think it has some relevance, she was unanimously confirmed by the Executive Council. A person with her skill set, I think, could make a contribution to the judicial management, if you will. That's not obviously anything I could speak to with any degree of personal knowledge, but I would suggest that. And I would think that it would satisfy the public's, any view the public had that anybody who is compensated in the judicial or any other system ought to be rendering services for that particular work. So that's the two pieces. You maintain the order in terms of her sitting on cases, which I think takes care of the public important issue number one about confidence in the judiciary. You let her maintain her salary, which would take care of number two, and also free her chief justices to assign her to administrative tasks, which I would suggest are plentiful. And third, it's attentive to the last of the important public interests, which is the independence of the judiciary, because you do not have to address those difficult issues under the approach that I'm suggesting. That is an issue which falls completely within the general superintendent's power of this court. I'd suggest that it is only when an order of this court under the circumstances that we have with Judge Joseph, touches her compensation, that is a bridge too far constitutionally. That is what brings this court right into the middle of a difficult and, frankly, in this circumstance, I think, unnecessary inquiry. So our proposal would be to keep in effect the order suspending her from exercising judicial duties, modify that order or whatever which would permit her to do administrative, non-judicial duties, but keep her compensation. And then thirdly, as far as the independence of the judiciary and the important matters that are attendant to this case, in that context, save that for another day. You do not have to deal with that in this particular context. I think the approach that we're suggesting is a path that I urge this court to consider. I think it is a path which satisfies the three important criteria that I mentioned. I think it is fair to the public. I think it is fair to the judiciary, and I think ultimately it is fair to Judge Joseph.
But ultimately, it rests on Article 29, doesn't it? If you don't have Article 29, you don't have a right that you're asserting.
Well, I mean, certainly it does. Is that because the constitutional issue I said you could avoid?
Yes.
I'm not sure, frankly. I mean, I think that.
What other right does she have?
Pardon me?
What other right does she have that the court officer doesn't have?
Well, I think that comes from Article 29, but I think that's not where the rubber hits the road constitutionally in this particular case. The rubber hits the road in this case, just because of Article 29 and any number of other provisions that affect judges. It hits the road when you want to take away from her a power. Let me make this last point. I'm sorry, I've way over my time.
It's all right.
The effect of this order in this particular case, I would urge you to consider, has a chilling effect on judges throughout this Commonwealth. It has a chilling effect because they worry now that something would happen to them that would cause a disgruntled litigant, a district attorney, to take some action against them, which under the Joseph scenario would be an automatic suspension of their not only service, but of their pay. I don't think, Your Honors, that is a hypothetical risk here. I have some experience representing a judge who was not favored by a district attorney, and in that context was the subject of a complaint to the Judicial Conduct Commission. So I don't think it's hypothetical. I think it's real, and I think it is a factor that every single trial court judge or probably other judge in the Commonwealth is aware of. Judge Cordy made reference to that in the case that I referred to a moment ago that I had some involvement with. So I just would throw that out as something for you to keep in the back of your mind, that the path that we suggest to you would be responsive to that concern, as well, we believe, as a concern that the other factors that I've mentioned.
Chief, I just have a couple questions, can I?
Of course.
Counsel, can you explain for me and for whoever else is paying attention, the statute that's involved that involves the appointment authority of the governor to employees and says that an employee may be indicted? I forget.
Yes. Chapter 30.
30, that's the one.
In
Does that apply here?
No.
Why not?
Because it's not applicable to judges. There's never been a decision of this court that said that chapter does apply to judges.
Is there any language in the statute that would preclude a judge from being included in that statute?
Well, I don't want to duck your question, Your Honor, except to say that I think this matter is probably better addressed within the briefs filed by the MBA and whatever than I can do. But I would say that Chapter 30, Section 59 in our judgment, and I will say I rely to a large extent on the arguments advanced by the MBA, does not apply to
I'll look at that.
judges.
My other I have two other questions. The next one is, what remedy, supposing that your client is not happy with our result today, her result here today, what remedy would she have? Would she have any other appellate remedies?
I don't think she would. I don't know. Can't think of any. This is sort of the
Okay, I'm just
That's
curious
where the
about
buck stops, I think.
about the contours of the constitutional argument.
Yeah, I mean, I haven't explored that, to be perfectly honest with you, because it's, once again, I think it's maybe an unnecessary inquiry.
And then you say that under our superintendent's power, you agree that, or you would concede that we have authority to suspend a judge from performing judicial service, like being on the bench,
Yes, I
correct?
do.
But we don't have authority, according to you, to withhold, to suspend without pay.
Correct.
If we don't have that authority, what teeth do we have in our superintendent's power?
Well, I mean, first of all, I think a suspension of anybody, and particularly a judge, is a sanction of some sort. I mean, it's not, no one wants to go around saying that she or he's a suspended judge. So I would suppose that is one thing. I mean, this case is, what underscores the uniqueness, I say, of this particular case is the underlying criminal indictment. And that prevents you, for instance, Your Honor, from conducting the kind of full-blown hearing that you might conduct if it was a commission on judicial conduct matter, or if it was a situation like Chief Justice Bonin's situation, because anything you do in that context is going to run into the Fifth Amendment and other issues pertaining to the criminal indictment. Oh, I'm sorry. Oh, gosh.
Modern era.
Sorry about that.
Let me ask you a number of questions. You've just identified, I mean, I think you may have said more than you intended, that clearly this court does have the authority to suspend without pay because we have done so.
Yes.
With regard to various matters, including a matter last year. And you point out that we did so after making findings.
Correct.
As a result of the Commission on Judicial Conduct. But you also recognize that that's not practicable here.
Correct.
During the pendency of a criminal indictment. So for all practical purposes, we don't have any ability to render that same type of investigation and finding, given
That's correct.
the existence of the
I agree
grand
with
jury investigation and now the pendency. So for all practical purposes, we would not be able to do anything, if we were to do anything at all, until the conclusion of until the dismissal of the case, or until a trial and a finding either of guilt or of
I
acquittal.
certainly think you could do nothing involving the pay. I think, as I've said earlier, and this may not be the major issue here, I think that there could be issues of the remedy that you could address. But I think the underlying criminal indictment puts this in somewhat of a different category. I would say this, and I think this is important. I think it's a price we pay. We pay, and I think the public would understand that. It's a price we pay to preserve the independence of the judiciary. It may not make sense to a lot of people, but other things that we do don't make a lot of sense. But this is so important, this whole issue of judicial independence and how this case can actually today be impacting on that particular power and responsibility of judges is, to me, the key issue.
Okay, let me also ask you with regard to the issue of remedy.
Yes.
Because of our obligations under the Code of Judicial Conduct, we have been very careful to do nothing or say nothing which could arguably affect the federal
Yes.
investigation and the federal trial. Is it your view then that every judge under indictment would be entitled to to be engaged in administrative duties regardless of the nature of the charge against him or her?
No, that's not my position.
Okay, so if this were a bribery case, which we know it is not,
yeah.
would it be your view that it would be appropriate for us to say that that judge should engage in administrative duties pending the adjudication of that case?
Yes, I hear you. I didn't mean to suggest that that under every circumstance. I actually picked this circumstance because I think that Judge Joseph has some skills that would be useful, and also I think the claim against her is nothing like bribery.
Understand that, but I guess then the problem is then, are we then faced with the challenging task then of evaluating either the merits or the nature of an indictment in deciding how we are going to proceed with regard to that judge? Are we to evaluate saying this is not a
Yes.
bribery case, it's a case of alleging obstruction of justice, or saying that expressing some view as to the quality of the evidence or the nature of the charge that should influence our decision as to what should happen with regard to her administratively?
I think that to the extent you decide to reach the issue of whether she should be permitted to undertake administrative duties, it's perfectly appropriate, I would think, to look at this underlying circumstance. You're not making a conclusion of guilt or innocence. The fact of the indictment, and that's what I think I was driving at in the first instance when I said we didn't quarrel with the suspension from judicial duties. This fact of the indictment, not the substance underneath it, but just the fact that someone has been charged in a very serious situation with an indictment might cause this court to say, in terms of what she would be permitted to do administratively, we have to give that a special consideration. So I think you could look at it under those circumstances.
Okay, and then I guess my last, but maybe I shouldn't promise to be the last question, depends on what your answer would be, but it goes back to the earlier question of Justice Kafker. So you identified 3 matters, but there is the fourth, which is a matter which was not in your brief, which is the existence of the personnel policy,
Yes.
which says that if any other non-judge in the trial court had been indicted for alleged misconduct in office, that person, quote, shall be suspended without pay until the conclusion of the criminal proceedings. So if one were a probation officer or a clerk or a court officer who would be faced under that policy with suspension without pay, despite all of the concerns which you raise, which we understand, what do we say to that probation officer or that court officer or that clerk to say, well, a judge will not be suspended without pay, but you will be?
Well, I think you have to go back to the issue of judicial independence. I mean, that's the key here. And I think a court officer or other person who works in the system who's not a judge would understand that. This is a constitutionally sanctioned position that all of you and every other judge in this Commonwealth enjoy. And it makes them somewhat different than a court officer or anyone else in the court.
Don't you think it also imposes more obligations on the judge than on the probation officer or the court officer?
It certainly imposes more obligations. In other words, that's part of the issue here, that it imposes significant obligations on that particular person, none of which I would suggest, Your Honor, are rebutted by an indictment, as in this
Can I
particular
ask
case.
a follow-up hypothetical question, not this one? So what if the judge asked the court officer to do something improper? The judge would be suspended with pay, and the court officer would be suspended without pay? And the court officer who's in a powerless position in certain ways? I mean, again, I'm not saying this is this case, but doesn't that present a problem if the court officer or the probation officer was acting under the direction of the judge?
You know, I don't know how to answer that, Judge Kafka. I mean, I can only say this, and I don't like to look like a broken record on this subject, but I think it's so important that maybe I should be. It really is a reflection of the independence of the judiciary. I mean, that is really the cornerstone of this particular argument here. And I think that in the circumstances you posed in the hypothetical, obviously it's a tough factual situation under the scenario that I'm presenting. But I would urge this court, in response to the concerns about the difference between the court officer and the judge in terms of the sanctions here, I would urge this court to be mindful, as I know you are, but in your minds to be mindful of the very special status that judges have in our court system. Their independence, going back to John Adams and earlier, is absolutely critical. And I would think a court officer or someone else in the court system who's been around judges for a while, which normally they have been, would understand the unique role that judges hold in our democratic process. So it sounds like kind of basic
So
constitutional
that's
law. I
what we
don't mean to be.
That's what we would tell the family and the court officer, that basically, we know you're suspended without pay, but gosh darn it, we've got a judge who has a special role.
Well, I think,
So this inequity that the chief pointed out to you, isn't that something we should take into account when we exercise our superintendent's authority over the entire judicial system?
I think you can take it into account, but you can't touch this compensation. I mean, that's the constitutional barrier you have. That's,
But the caveat you told us in the beginning is the judge has a right to compensation under Article 29 as long as the judge behaves well.
correct. So what's
You
the,
stick with
so
that.
what determination under your hypothetical has occurred that would say to you that the judge has not behaved?
Well, I guess where the rubber meets the road is whether or not an indictment by a federal grand jury suffices to prove that the judge has not behaved well. And that's where you say it doesn't, and you say we should only make the finding that the judge has no longer behaved well up until the point the jury says guilty, correct?
Absolutely, absolutely. The jury instructions that you and Judge Gantz and anyone else has been part of in the federal system as federal prosecutors say as much. The indictment's a piece of paper. It's not, it's a charge. It says nothing about the culpability of the defendant. So if that has to be explained in those terms to the court officer's family, I think it has to be explained. I think it's critical, and it may take some long explanations, but I think it's baked into our democratic process. And I think this court, I urge this court to be attentive to that in the disposition of this case.
Let me take one step further. The trial court policy, of course, you're absolutely correct that there has been purely a finding of probable cause. And you're also correct that if this had been a Judicial Conduct Commission matter and it had come to us, a finding of probable cause would not be sufficient for us to take any action. We would require there to be, at the very least, preponderance of the evidence before we were to take any action. Should we, as part of our superintendent's function, revisit the trial court policy, which itself is essentially a determination that a probable cause finding?
The one that Judge Kafka referred to? I suppose you could, if it made it more understandable to the people that are subject to that, I suppose you could. I think that's within your general superintendent's power if you want to give them the benefit of the same kind of protection that you would give a sitting judge. It doesn't present a constitutional issue, in my opinion.
And going back to the constitutional issue, I'm a little bit confused. You began saying we don't need to reach this, that you said it's a matter within our superintendent's power, and we don't need to reach the constitutional issue, and then you're saying it is a constitutional issue. I'm trying to understand whether or not you're arguing
I think
that prudentially, even if it is within our superintendent's power, we should, given the issues of the independence of the judiciary, exercise our judgment to not exercise that authority? Or are you saying that we do not have that authority under our superintendent's power in the absence of a finding after investigation and hearing of wrongdoing?
the latter. I mean, certainly, whether you have it at all is another question. That's a question addressed by the Mass Bar Association. But certainly, in the context of a case like this, without anything more than a federal indictment and a plea of not guilty, you do not have the authority to do it. And I don't, frankly, think it raises a constitutional question, with all due respect. I mean, obviously, the Constitution's at issue because you're all sitting here as a result of the Constitution, and every other judge is as well. But as far as getting that tough issue, which I think is a very tough issue, resolved, I suggest to you, you do not have to reach it in this case to effect a fair resolution of this matter.
That's what I don't understand. That's what I don't understand. Why don't we have to reach it? I don't understand why we don't.
Because I suggested under your general superintendent's power, you have the power to suspend.
But not the power to suspend without pay.
Correct.
And that's what I don't understand.
Well, that's the,
If you take the Constitution out of it, that's what I don't understand.
well, I'm talking in terms of what I suggest you would do, which is suspend with pay. That doesn't raise a constitutional issue. If you decide you want to suspend the pay, that is then you're backing into Article 29 or whatever.
So in other words, in order to prevail today, you have to show us that this is an Article 29 issue.
I don't think so. I mean, that's my point. I think that you can address the issue of a suspension and don't even think about Article 29.
Only if we were limiting ourselves to a suspension.
Correct.
But a suspension without pay, I guess, is the issue.
Yes, I understand, Your Honor. If it is this court's view, which I hope it is not, that you would suspend without pay, I think you are absolutely correct. You are in the middle of a significant constitutional question.
Okay.
Can I follow up on that? Just one more question, Chief. Administrative Justice of the Housing Court Department versus the Commissioner of Administration. Are you familiar? That's the famous DeHare case, where the legislature lowered the salary of the Chief Justice of the Housing Court.
Yes.
We said that didn't present a constitutional problem, right? I'm trying to understand where the Constitution kicks in on this. I understand your argument. You can avoid all of this by suspending her with pay.
Correct.
But you're suggesting that if we suspend without pay, we're running into the Constitution, but I'm trying to understand what it is we're running into, because I understand if we're lowering Chief Justice Gantz's salary, that runs right into the Constitution, or one of us, but we've drawn a distinction between the SJC salaries and all other judges. Whether that makes any sense or not, I don't know, but the case law draws that distinction. So I'm trying to understand where Article 29 creates a salary preservation right for lower court judges, trial court judges, appeals court judges, anyone else, because the Constitution only references the SJC on that salary.
And I'm not going to be able to cite any authority to you, Judge Kafker. I think it's cited in the Mass Bar Association's brief, but I believe that statute is deemed to be applicable to all judges.
Yeah, I read the footnote is sort of in that brief doesn't really address the problem, which is that we have drawn these distinctions in DeHare and other cases.
I guess what I would say is this. The path that we suggest to you, and I recognize Justice Link's comments and also Justice Kafka's comments about, aren't you dealing with a constitutional issue anyway? I think what I'm trying to suggest is that the approach that we suggest bypasses that issue. You don't have to confront it. If I thought you had to confront that issue, I'd be arguing what the Mass Bar Association argues, an argument I think I could easily adopt, by the way. I'd have to argue it. I don't want to argue that here because I don't think you have to reach that issue under our approach that we suggest to you. I think you can leave that issue to another day. I think it's under the approach that we recommend. It's unnecessary for you to do so. It's a difficult issue anyway, and I think it's something that you don't have to address if you adopt the path that we suggest that you adopt in this case.
All right. Thank you.
So, thank you.
Court all rise. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices, the Supreme Judicial Court, now sitting at Boston within and for the Commonwealth. At present apart, the sitting of this court is now adjourned. God save the Commonwealth of Massachusetts.